And I will give you rights to share screen in case you need to share something.
Yes, I'll be sharing a presentation. I'd also like to ask the participants, if possible, for them to turn their cameras on and maybe join the discussion when we present certain questions and issues for discussion. Okay, so yes, this should be the. So today's presentation will be about building a case theory and also about the IRAC method, which is the way you present that case theory. But I believe it is very important to first discuss what a case theory is and how to build a proper case theory. Now, in moot court cases, the case author has done a little bit of the work related to building a case theory for you. But still, I believe that you have a lot of choice in the way that you present your arguments, both in written and in oral form. And this is related to how you build a case theory and how you present it during the Jessup moot court. So just one first question, and this is to maybe generate a certain insight among the participants, and feel free to join in the discussion, please. And one question would be, why do we choose to litigate? And this is a question I would like to pose to you, because I want to discuss how to approach your role as a moot court contestant or as part of a team. Why do we choose to litigate regularly? What can you think of as an answer when you decide to go to a tribunal and litigate on a certain issue? What are we expecting as an outcome? So would anyone like to share their opinions, or maybe in the chat? If not, we will continue. I'll provide my own ideas, but it would be nice to hear from you. Okay, as I see no answer so far, please feel free to interrupt me at any time if you have questions as well, or write them down in the chat. But as I see no intervention so far, you have to bear in mind why we choose to litigate, and this should inform the way you participate in the competition. We don't choose to litigate because we want justice in an abstract sense. I mean, of course, every one of us could agree that justice is an important goal, but it's not what we're doing, right? When we choose to litigate, this is because we've had a situation, a controversy, and there is another party to this controversy, and we wish that this other party would act in a certain way. But since we cannot force them to act in such a way, when dealing, for example, with Jessup cases, one country cannot choose to bomb another country and bend that other country, or bend a foreign government to its will by using weapons, for example. So we have an obligation to settle disputes specifically, and then we go to tribunals such as the International Court of Justice. And what we do is we let the tribunal know of what's going on, and we ask the tribunal to declare that the other party should act in a certain way, or that we have the right to relief, and they should pronounce themselves in a certain fashion. So this is very important to bear in mind during the competition, because what you do when you present arguments is to try and convince a third party to say what you want them to say, so that the other party to the dispute will act in a certain way. That is the result you want. So when you present your arguments, always make it very clear from the onset what you wish the tribunal to declare. For example, members of the panel, such and such measure adopted by such and such government is incompatible with Article 5 of such treaty, right? You're making it very clear from the onset. And this should also help you avoid what could become a very academic discussion with as law students and as moot court participants or contestants. We sometimes forget that our job is to convince, and it is not to have a beautiful discussion, a deep discussion on a certain treaty or on the nature of genocide or on the nature of sovereignty, but rather to present a compelling cause for the party which we represent. But with this in mind, remember that there are two types of simulations when it comes to simulated dispute settlement processes. We have, on the one hand, moot courts, Jessup is a moot court competition, and we have mock trials. Mock trials are usually based on evidence, the taking of evidence, the presentation of such evidence, and moot courts are normally centered on issues of law. So we take the compromise in the case of Jessup, or we take the case as valid, as true, and then we center ourselves on issues of law. This is what you do in a moot court. This was another question to try and promote your participation. I don't know if we'll be getting some of that today, but this is a question that would lead up to discussing case theory, right? But one question would be how to deal with unfavorable facts when we represent a client as lawyers or as members of a national delegation before the International Court of Justice. How should we deal with unfavorable facts? And what I've seen from law students and even from lawyers, at least in Guatemala, is that there is sometimes this tendency to say, oh, we won't mention this. This is too unfavorable for us. We won't bring it up. Or we should only deal with it if it is brought up during the hearing, but otherwise we're not dealing with it. And I like to provide an example or a comparison. Say that I had a car accident, I crashed my car, and we want to know what happened. And then I go on over and over saying that, well, I was driving, the light was green, I had the right of way, but then there are certain empty whiskey bottles in my car, which were found at the scene of the accident. And I only talk about the green light and the speed limit, but I refuse to talk about those whiskey bottles. That could be a possible and unfavorable fact, because it could mean that despite my apparent compliance of the law, I could probably have been drunk at the time of the accident, and that, or had been under the influence of alcohol, and that would change things significantly in determining responsibility. However, there are different ways of telling the story about the bottles, right? I could say, well, those empty bottles are bottles I used to produce artisanal honey. I have my own bees. I produce milk. I'm sorry, not milk, but honey. And I was just carrying them for the purpose of filling them up with honey later. And so I'm a hardworking man, which simply happened to have an accident. Or you could say, no, I mean, this guy was actually drunk. This guy had emptied down 2 bottles of whiskey and he crashed. Yeah, as you can see, there are 2 different ways of telling that story, right? But these bottles could be a very relevant element to that story. And if I avoid discussing about those bottles, then I could maybe not be doing the best possible work for my client, right? So this question on how to deal with unfavorable facts leads me to what a case theory is, and then we'll discuss a little bit on how to build a case theory. So basically, when we talk about a case theory, we're talking about a story, the story of what happened in a given case, in a particular case. It involves both a legal and a factual theory, right? Not only what happened, but also what that implies legally. And it should always be a detailed, coherent, and accurate or very precise account of what happened. So in a nutshell, the case theory you have to present when you argue a case is a detailed, coherent, and accurate account of what happened. And of course, what that implies legally, right? So you will combine your factual and legal theories. Now, there are certain aspects you should take into account when building a case theory. One of them would be a case theory should always be based on strong facts and inferences that can be fairly drawn from these facts. This is importantly relevant if you are deciding how to present a case theory, but not in the situation of a moot court case. A moot court case will give you the facts. And yet, a moot court case will always leave a certain room for ambiguity. So you got to make sure that when presenting your arguments, they are based on solid facts on the record or the company. A case theory should be built on facts not subject to much or any dispute. It should be consistent with any incontestable fact, right? You could build a magnificent case theory and present wonderful legal arguments, but there is an incontestable fact that will make it irrelevant or will make it not appropriate. Say the empty whiskey bottles. Was I drunk or was I not drunk? You should address that. Your case theory should address that in that case of the car accident. Otherwise, it's probably an incomplete case theory. It should also take into account and explain away as many unfavorable facts as possible. When doing a moot court, usually cases are drafted in such a way that there will be some favorable facts for one party, some favorable facts for the other. But it is your job to really try and take into account as many facts as possible, and especially those which might seem unfavorable. And this is particularly relevant because those are the facts that judges or panels are likely to ask about during your hearings. So you really need to prepare in such a way as to be able to address those apparently unfavorable facts. Your case theory should be accepted by the trier of fact, in this case, the court, the tribunal, without having to stretch the imagination, right? Oh, since we're talking about this type of agreement, it is reasonable to think that there was also a non-disclosure agreement associated to this contract, right? An NDA. Well, but can you produce the NDA or not? Or are you asking me to imagine that there was? So this is also very important. You need to use the compromise. You need to use clarification questions in a Jessup competition, but do not ask the judges or justices to stretch their imagination. Oh, but we can suppose such and such thing happened. And it should also not be based on wishful thinking about any aspect of the case, right? So with this, having said this, how can we develop a case theory? These are other tips. One is to construct a factual chronology of the case. Now, in moot courts, you have a case which is usually presented chronologically, but still it is recommendable, I think, to construct a very simple chronology or timeline that will allow you to understand the case very clearly and to present the facts very briefly if needed. But also, you should analyze the case from a common sense perspective and ask yourself questions such as, what's the essential wrong or unfairness to the client? This tips or this advice is mostly applicable when you're building a case theory from zero. You're not presented a hypothetical case with actual causes of action, but say this is really useful if a client comes into your office and you need to decide how to present a case if you're going to litigate. However, this question is still relevant for moot court participants, I think. Because even if cases provide the causes of action and the particular claims presented during a case or counterclaims, There is often wiggle room in the way these claims are presented, and you need to make certain choices. So these common sense questions could help you. For example, on the field of trade, which is what I do, international trade policy, it is one thing to say a measure is discriminatory, but it is another thing to say it is de facto discriminatory or de jure discriminatory. Or it is one thing to say that such law or act adopted by a country is incompatible, but to try and identify the particular provisions of those laws which are incompatible with a treaty, that could require more work. So even within the context of a moot court, or in other scenarios, which I think very important to ask yourself this kind of questions, because this will help you build a case theory. If you have determined what's the essential wrong or unfairness committed to your client, then that is a message you want to convey during the hearings or in your written submissions. Another question could be, does this unfairness suggest any causes of action or defenses that are not obvious to you? Well, as I said, in a moot court case, the causes of action are predetermined, but sometimes there will be an argument regarding lack of jurisdiction of a particular tribunal in a moot court, and you still have to decide the particular basis to claim a lack of jurisdiction, for example, as a defense. So it's not completely irrelevant to think about this. You should identify any facts that make the cases special or more appealing. This is very important, I think, and you also need to be able to identify those facts that help your cause in a very clear and concise way. You should identify any theme or unifying principle that these facts suggest. Now, this is very important. Oftentimes, we might think that it is enough to do research and to understand the law applicable to the case and to understand the facts, but you want to identify a unifying theme for those facts, especially, or a unifying theme for a particular claim, right? And that will help you convey your message more clearly and present your arguments in a more concise manner. And it will also make you seem as a more coherent person. Oftentimes we may look cynic when presenting an argument because we're speaking about the law, we're speaking about facts, but we forgot to find this unifying theme or principle. And according to the law, we might be not responsible for a certain action, but yet we fail to grasp how important it is on how we present our arguments and find a theme or unifying principle that will present us in a good light. Remember that we're dealing with human beings, and we need to convey messages which are convincing for human beings. We'll deal with this issue of identifying a theme or unifying principle in an example I have prepared for you. We should also identify the legal theories or causes of action or defenses that could be relevant for the case, and then identify the elements that you must prove to prevail on each cause of action or defense. Oftentimes in a moot court, it might seem viable to present a certain argument under a certain article, and then we realize that maybe the case and the clarification questions did not provide the necessary facts to argue in such a way. So in that situation, there might be another way of presenting that argument. There might be another theory to invoke, and you should always do that. And with these questions, with common sense questions, you can always build or a better case theory. So I should like to present to you a particular case. As I said, I work at CIECA, the Secretariat for Central American Economic Integration. And at CIECA, we manage an interstate dispute settlement system, particularly for the trade disputes that arise between the members of the Central American Economic Integration subsystem, the countries I mentioned earlier. And this dispute settlement process has 4 phases. One of those phases is arbitration. This case in particular, the case concerning the fresh tomato imports reached the arbitration phase. And this is what I'd like to present to you as an example on how to build a case theory, and maybe hopefully we could criticize it together if you'd like to participate or present comments in the chat. So what happened in this case? Before we get directly into what happened, I'd like to provide a little bit more context. As I said, Central America has an economic integration process, which goes from the establishment of or the formation of a free trade area, which implies reducing tariff and non-tariff barriers between the trade. For the trade between Central American countries. But it also involves other stages which imply a higher degree of integration. For example, a customs union, a common market, which would imply the free mobility of production factors, a monetary integration process regarding fiscal and monetary policy. And finally, the end goal of this whole process would be an economic union, which would be a supranationality arrangement regarding the economic policy of this region. As of right now, Central America has already formed a free trade area, and it is in the process of forming a customs union among the 6 state parties to the Central American Economic Integration Subsystem, which is a part of CRAC. This process is subject to a community law system. It is governed by certain treaties, which were signed, of course, by representatives of the Central American states. And through these treaties, we have also created certain regional bodies which are capable of interpreting, applying, or adopting adopting laws of a regional character, which are not international treaties per se. They are binding rules, but they are simply community law instruments that can be adopted by these regional bodies because the founding treaties of our economic integration process created such bodies and gave them those powers to adopt such rules. I mentioned this because we're going to be speaking about a case regarding community law in Central America. We have a dispute settlement system. It's called in Spanish Mecanismo de Solución de Controversias Comerciales entre Centroamérica, which, as I said, is a state-to-state dispute settlement system. It is mentioned in Article 35 of the Tegucigalpa Protocol, the founding treaty of the Central American Integration System, the CICA, and it is also regulated in resolutions adopted by the Council of Ministers for Economic Integration, a regional body with regulatory powers. Its scope of application is as listed here, as follows. As you can see, it applies to it applies to 3 scenarios: the prevention or settlement of disputes related to the application or interpretation of regional legal instruments. By regional, we mean Central American. And there are 2 types of disputes that could be brought up to this mechanism or system. First, measures related to the violation or breach of regional instruments. These are disputes which are generated when a country or a state party deems that another state party has breached its obligations or commitments under a regional treaty or a regional legal instrument. And there are, of course, situations where a measure causes nullification or impairment, but not necessarily breaches a regional agreement. These are known as non-violation cases, and they would not require that a measure is incompatible with the text of a treaty, but yet a certain decision or conduct of a country or of a government has resulted in a reduction or in an elimination of a certain benefit which accrued from the signing and entry into force of a regional instrument. Now, this is not as important or as relevant. We are here to talk about case theory and how to present your arguments, but I just wanted to give you this information before we go into the case, because it'll help you understand it better. We're dealing with a violation complaint in the case we're addressing right now. So as I said, our dispute settlement system has 4 phases. This is in Spanish. I'm sorry, but it comes from another presentation. But the third phase is arbitration, and the case we're dealing with or will be analyzed during the arbitration phase, not during previous phases. The arbitration phase should normally take about 90 days in our dispute settlement process. However, it could take longer, or it could have different terms as agreed by the parties, or even as decided by the tribunal in consultation with the parties. But these are the basic phases of the basic steps. Yes, actually, procedural. The most important procedural aspects of the arbitration phase: the confirmation of the tribunal on the basis of a request for the establishment of a tribunal, a complainant written submission, a respondent brief or reply written submission or brief, then a hearing, and then supplementary written submissions by each party referring to what happened or what was stated during the hearing, and then the issuing of the award, which should take the last 30 days of this 90 days procedure. However, as I said, these rules are pretty flexible, and certain procedures have taken far longer than these. Some have taken just a little bit longer than this, or it could vary from case to case. Okay, so let's go back to the case I want to present to you today, the case concerning fresh tomato imports in Panama. This is a case which occurred between the republics of Costa Rica and Panama. Costa Rica as complainant, and then Panama as respondent. It related to certain measures affecting imports of fresh tomatoes. This is the Solanum lycopersicum would be the scientific name of this vegetable variety or species. And Costa Rica presented multiple violation claims, as I said earlier. The term measure, by the way, should be understood in a very broad sense in our dispute settlement system. Measure refers to any act, any omission that is attributable to a state, right? For which a state can be held responsible. So a measure could be the enacting of a certain law, or it could simply be a certain behavior by government officials, or even an omission by government authorities. It is a very broad term. So Costa Rica presented multiple violation claims regarding sanitary and phytosanitary measures, and also free trade and non-discrimination, for example, based on the rules of our economic integration process. So certain important aspects of the case, we're going to be centering our attention on SPS measures, or sanitary and phytosanitary measures. There were other claims, of course, but I don't know if any of you is familiar with the term sanitary or phytosanitary measure. Would any of the people in the meeting, I see we have, I think, 7, yes, like to tell us if you're familiar with the term? Or you could write it down in the chat. But basically, sanitary and phytosanitary, and feel free to interrupt me if you want to join in the discussion, but sanitary and phytosanitary measures are measures adopted to protect human, animal, or plant life or health. That is their objective, and they protect these assets, these goods, human life, human health, from certain types of threats, such as plagues or pathogens or disease. They would protect vegetables from plagues coming from other territories different from the national territory of a country. And each country in the world is, as a sovereign country, is free to adopt sanitary and phytosanitary measures. However, these measures can be highly trade restrictive. They can constitute a barrier to trade. Say, for example, if one country were to decide to ban the import of a certain good coming from another country, ban the imports of tomatoes, ban the imports of any produce, agricultural product, because it detected the presence of a plague in those imports, then that ban on imports would have a severe impact on trade, and it could have a potential disastrous effect for certain people in the world, the producers of those goods. So countries are free to adopt SPS measures, but as long as these SPS measures comply with certain requirements. And we're going to be dealing with Article 4 of the Central American Regulation on SPS measures. This is a regional legal instrument which governs the adoption of SPS measures by Central American governments. So SPS measures adopted, applied, or maintained by a state, according to Article 4 of this regulation, shall not create unnecessary obstacles to trade, right? They can pursue a legitimate policy objective of protecting, say, vegetable life and health from certain threats, but not in such a way that they create an unnecessary obstacle. They should be based on a risk assessment, right? It is one thing to say, oh, I have identified a certain plague in imports from a certain country, but does the presence of that plague represent a risk for your country? What is the risk? If you don't have that information, then you cannot really adopt an adequate SPS measures and define the adequate level of protection and the required actions to take. Oh, sorry, something happened here. Okay, so I'm sorry for that. SPS measures should not be more trade restrictive than necessary to achieve the adequate level of protection desired by the country adopting the measure. Say, if the level of protection is, I want zero presence of this plague in my territory, or we want to control the spread of this plague as it is present in certain parts of our country, but not in others. So we will adopt measures to avoid the spread of this plague. They should also be based on measures, standards, or recommendations of relevant international organizations. And another important principle laid out in Article 4 of the Central American Regulation on Sanitary and Phytosanitary Measures, SPS measures, is that there should be no retaliation for a properly adopted SPS measure, right? Because countries are free to adopt these measures as sovereign states can exercise their sovereignty to adopt these measures. And if they do so correctly, well, there should be no retaliation for this type of measure. And with this long introduction, I'm sorry, I hope this is being informative. We can get into the case in question, the case concerning the imports of fresh tomatoes to Panama. And this is where we will be addressing one of the reasons I want to present a case to you regarding my own experience. I am the manager of this dispute settlement system the CIECA manages, the CIECA administers. So I want you to see how important it could be to build a case theory correctly. And I want you to see that it has an impact in real life, right? This is why I'm choosing to present this case to you. And I hope this will provide valuable lessons. So some basic facts of the case we're going to be discussing. This case concerns the imports of tomato, fresh tomato, to Panama, and particularly Costa Rican fresh tomato to Panama. And it is related to this little insect that you see here. This is the Tuta absoluta, that is the scientific name, or simply Polilla del tomate in Spanish. But it is an insect which affects tomato plants. It can be pretty destructive. And this case, as I said, involves Costa Rica and Panama. As Panama adopted 3 resolutions, their local authorities, which are competent to adopt decisions on sanitary and phytosanitary measures or relating to the sanitary and phytosanitary status of Panama, adopted these 3 resolutions according to Costa Rica. You can see the numbers here, right? Number 467, 2007, etc. It's not important that you remember those numbers in detail. But the first resolution established SPS requirements for the importation of tomatoes to Panama, adopted in 2007. Then in 2010, Panama issued new SPS requirements, particularly for the importation of cherry tomatoes. This is a particular subtype of tomato. And then in 2011, there was an additional resolution adopting emergency sanitary and phytosanitary measures, according to the text of the resolution itself. This resolution reviewed Costa Rican tomato export notifications to Panama. So before exporting a vegetable or any type of biological material which could affect the sanitary and phytosanitary status of another country, say the presence of a particular plague, etc., there is usually a notification of that export by competent authorities in the exporting country to the relevant authorities in the importing country, right? So it reviewed certain notifications that Costa Rica had performed regarding the intention of certain producers to export tomatoes to Panama. Then this resolution also requested additional information to Costa Rica regarding tomato exports. And then it reinforced certain sampling measures related to tomato imports, right? Sanitary and phytosanitary measures can look very differently. For example, we could be speaking about mandatory fumigation, right? We could be speaking of sampling of imports of a given product. We could be speaking even of a ban on imports, right? So a sanitary and phytosanitary measure can have a very different character depending on the particular risk we're dealing with. And then an important fact is that we've had no tomato exports, according to Costa Rica and to Panama since 2011. So there have been no Costa Rican tomato imports to Panama since that year after the adoption of these resolutions. So one question here is, how should Costa Rica tell its story? Remember, we're dealing with SPS measures. SPS measures should not be more trade restrictive than necessary. And as we see from the facts of the case, at least the ones that Costa Rica itself provided, there have been 3 resolutions regarding SPS measures applicable to tomatoes. And then there is also the fact that there have been no tomato exports to Panama since 2011, after the adoption of resolution OPSA CTI 017-2011. So I haven't had any success with anyone joining the discussion. Do you think it is likely, Claudia, that anyone will like to share their insights on this? Or should we go on?
I think we should go on. We have a very quiet audience in most of the sessions, sadly.
Well, that's that's unfortunate. But do you think they're paying attention at least? I'm a bit concerned.
I think they are. Just that some of them are, I think at least a couple of them are in a very, very bad schedule time.
Time zone?
Like in the morning.
Oh yeah, see, Juan Pablo Borges, we are, he said. Okay, no, I'm glad to know. I'm glad to know. But maybe Juan Pablo, you'd like to share your insights as to how Costa Rica should tell its story in this case.
You can use the chat if you're not feeling like talking. I can read the answers if you want.
Yeah, I have the chat right in front of me. If not, don't worry. There's no no pressure to do so, or no requirement to do so. Okay, so we could think of different ways in which Costa Rica could present its case and how it should tell its story, and then possible unifying themes, right? Because as you can see, this case involves 3 different resolutions. So one question is there a unifying theme for these 3 resolutions? And so one way that Panama could conduct its litigation is to challenge each particular resolution, or maybe challenge the 2011 resolution, which is the one that seems to be affecting it the most, and bring a claim against resolution OPSA CTI 017-2011 because it breaches Article 4 of the Central American regulation on SPS measures. That is one possible way of doing so. Maybe if there would be a challenge, an individual challenge to each of these measures, then it could be harder to present a unifying theme in the case theory. But there is also the fact that there have been no tomato exports since 2011. So this could be a possible unifying theme, right? And this could be the measure itself. We're not challenging each particular resolution. What we're challenging is the fact that you have banned, or practically, for all practical purposes, banned tomato imports from Costa Rica to your country. Let's see what they did, and hopefully this will provide important lessons or insights for you. So in its initial written submission, paragraph 90, Costa Rica stated the following, right? The measures supposedly adopted by Panama were not actually applied, right? This is referring to the resolutions I mentioned, the SPS resolutions. Instead, but by resolution, we mean an administrative provision, right? It's just that is a name that would be used in Panamanian legislation. Instead, the most trade restrictive measure was applied, a de facto ban on market access, or a ban on imports, right? So the term de facto here refers to the nature of the measure. It's not that Costa Rica wanted to challenge the particular text of one of those resolutions, but how they effectively became to be applied and their actual effects, which is that de facto, they no longer can export tomatoes to Panama since 2011. So as you can see, Costa Rica here is building a case theory, and I think they chose a pretty powerful unifying principle, a de facto ban on imports. What really happened, what's actually happened, is we can't export. Now, it is also a bold choice. First, because it requires the tribunal to recognize this de facto ban on imports as an actual existing measure, and they will have to prove that it exists, right? And it is also a bold choice because if it is found that this measure is incompatible with Central American legal instruments, regional instruments, it could still be the case that by not challenging the particular details of these OPSA resolutions, these national resolutions, that then Panama, they will have less certainty as to what Panama should do to comply with the award, with the arbitral ruling or award. So it is a bold choice, but it is also a choice I think I like, or I myself find quite interesting, right? Which is they found a unifying principle and theme, and they also provide a very clear notion of what's the essential wrong or unfairness committed against, right? It's we can't export, and the rules are here so that this won't happen, right? The rules are here so that Panama will still be able to protect its tomato production from foreign players, but in such a way that maybe they won't need to ban this import. So I like this case theory or this theme from for various reasons. As you can see, here Costa Rica is referring to how the tomato trade between Costa Rica and Panama has been significantly affected. They provide data. What's very important here, I think, is that this data was taken from Panamanian statistics. They went and took the official statistics of the Panamanian government, which I think makes the argument more powerful because this is a fact that Panama would need to accept. The only way Panama could deny or challenge these facts is by lying during the procedures, which is highly unlikely to happen, and it actually didn't happen. So I like it, and as you can see, they're telling their story. Before the de facto ban on imports, Costa Rica exported such 110 tons and 171.8 tons in 2009 and 2010 should be here respectively. Likewise, in 2011, the year in which the de facto ban on imports was adopted, a total of 38.3 tons of tomatoes was registered, which reveals a drop of the amount of exports. So as you can see, Costa Rica is laying out their story. We go from scenario A, a good amount of exports to Panama, an increasing amount actually, but then in 2011, when certain measures were adopted, we see a decrease, and this is the punchline here. As of 2012, Costa Rican fresh tomato exports, I'm sorry for the tomato, but tomato exports to Panama had completely disappeared, and this situation remains to this day. So this is the message they chose to present, and they also presented these tables in their initial written submission, and I think the request for the establishment of a panel. And as you can see, there are in fact no registered imports of Costa Rican fresh tomatoes to Panama since 2012 onwards. This is very crazy things. Sorry. Okay, so okay, so as I was saying, well, Costa Rica presented this small table. Sorry for that. And then this is what Costa Rica is doing. And then let's see what Panama did. As evidenced by these facts, this is the reply brief, paragraph 28, presented by Panama. The measures adopted by the competent authorities of Panama respond to an emergency situation resulting from the detection of the tuta absoluta plague. Now, before going forward, Panama could opt for different strategies. As a respondent, you don't need to actually present a case. You could dedicate yourself to simply challenging the complainant's case, saying the complainant couldn't prove such and such thing, the complainant didn't meet its burden of proof. And I think also Panama could have had different themes or could have emphasized different aspects. As you can see from this paragraph, they're probably going for restating their right as a sovereign country to adopt an SPS measure. And this is good enough, I think this could be a good enough strategy, but remember what I said earlier with the example about having a car accident and the empty whiskey bottles. I think there are certain empty whiskey bottles here, namely the statistics that Costa Rica presented, which are actually Panamanian statistics. And let's see what they did with that. So they're saying here, we adopted valid SPS measures. Then Panama states in their reply brief, Panama is not responsible for Costa Rica's failure to provide the information required in such and such resolution, right? So they're doing some blame shifting, saying we adopted measures. It was up to Costa Rica to comply with those measures, which have a legitimate policy objective, which is to protect our tomatoes from foreign plagues. One important thing to notice in this case is that there was tuta absoluta in Panama. There is tuta absoluta. There is a presence of the plague, but it's just not present in all of their territory. So actually what they're trying to do is to control and contain the plague, but it's not that they have zero presence of the plague, right? And this is also an insect which flies. So country borders might not stop it from flying to one place or from one place to another. And then Panama goes on here regarding the economic impact of these measures, and remember the statistics we mentioned. Costa Rica has not provided evidence during these procedures which show the alleged adverse economic impact of the SPS measures adopted by Panama. It has only provided documents produced by a private party whose interests are at stake in the present dispute related to the estimated costs, which were supposedly incurred to comply with the operational plan. Now, this is true. Costa Rica did produce an affidavit by an allegedly affected business, particularly a tomato producer and exporter. But it is also true that Costa Rica had presented the statistics we mentioned before. So this is the initial position of Panama. Then during the hearing, as we can see, Costa Rica is here basically restating their position. They're sticking to their case theory. This is during the hearing as well, and this is Panama stating there has never been a de facto ban on imports nor a state of uncertainty or defenselessness for Costa Rican authorities regarding compliance with the measure, right? And then it says Costa Rica has presented arguments which do not take into account the content of the resolutions in question. I like this way of stating things a little bit more than their reply brief. There has never been a de facto ban on imports. Actually addresses the way Costa Rica presented the case. And then, and I'm sorry, this is in Spanish. This is, but I wanted to keep this here because this is a screenshot of an actual question of the tribunal to Panama, right? So far we've seen what the exchange has been between the parties, and I will translate for the English-speaking participants, right? So this question was issued by the tribunal and was presented to the parties so that they would answer it. The arbitral tribunal, under the rules of our dispute settlement system, can do this. They have the power to directly ask questions to the parties to the dispute, and these were presented in written form. And it states, Costa Rica presents information regarding the volume of Costa Rican tomato importations in Panama. The last year in which importations were registered is 2011, with 38.3 tons. Now, and they're asking Panama here, remember the empty whiskey bottles, right? Could Panama confirm the information or the data regarding Costa Rica importations of Costa Rican tomatoes for 2011, and whether the customs clearance for Costa Rican tomatoes imported in Panama happened in full before the entry into force of resolution such and such of July 7th, 2011. Now, let's see how Panama's answer is compatible, or to what extent it's compatible to how they've been presenting their case. So the answer, Panama confirms that the volume of tomato imported from Costa Rica during 2011 was 38.3 tons, and that all of these import operations all of these imports were nationalized before the entry into force of resolution OPSA-CTI 017-2011 of July 7, 2011. To sum it up, what's happening here is that the tribunal decided to ask Panama, okay, so Costa Rica is alleging that after you adopted certain measures, they could no longer export tomatoes into your territory, certain SPS measures. And then Panama confirms this because, of course, these were Panamanian statistics. They couldn't have lied about it, or that would have been outrageous, right? And so they confirmed this. And I want you to think of how this relates to how Panama has presented its case so far as a respondent, because they hadn't dealt with this particular issue of the statistics presented by Costa Rica. And so the tribunal, this is in Spanish, but I'll sum it up for you. This is a fragment of the award. It's just there, so you can see that this type of discussions on how to present arguments have an impact in real life. But the tribunal sided with Costa Rica on this issue, and they considered that the de facto ban on imports was adequately proved by Costa Rica. And in this paragraph of their award, they actually quote Panama's own response to the question, right? To the question they presented earlier, this question. And they quote Panama and they say, well, Panama itself has admitted that such and such thing happened, and therefore we believe there is a ban on imports. And then furthermore, the tribunal found that such ban on imports was in breach of Article 4 of the Central American Regulation of SPS measures. Now, and then we'll get into IRAC just after this. But I want you to have this case in mind and remember some of the things we said earlier, right? We stated that a good case theory would be consistent with any incontestable fact. And from what we see that the parties did, for example, Panama's response to Costa Rica's claims would have probably had to take into account these statistics that were initially presented as they were their own statistics, right? And to address them directly. But not only to address them directly, but to present them in such a way that was more favorable to them. But since they decided not to do so, and this only came about as a result of a question presented by the tribunal, then they had no control over how this was seen by the tribunal, or they had less control. And so this is, I think, a good lesson on how you should build a very coherent case theory, and how you should have a very coherent approach during the Jessup competition. I've seen this happen during hearings. I've seen it happen. Like students present a good argument, but then they get asked a question about a certain fact which appears in the compromise and that they had forgotten about, that they had chosen not to talk about, and then their whole theory crumbled. So it is your job to bear in mind that it is your job to build a consistent and coherent case theory. And remember, you're defending a client and you're trying to convince a tribunal, right? The case theory should take into account and explain away as many unfavorable facts as possible. And so I think the way both parties acted in this procedure, and this is of course a very summarized version of what happened regarding certain claims in the dispute, can be an example for you on how to build and present an argument. Also remember what we said on how to develop a case theory and this common sense perspective, right? what's the essential wrong or unfairness to the client. Now, this common sense perspective might seem sometimes as a waste of time. I remember as a moot court participant, I would think, I mean, we already know what's wrong. What's wrong is that such and such government decision breaches an international treaty. That's it, right? But it's not as simple. And if you think of what Costa Rica did, for example, regarding this claim, they were good at identifying the essential wrong or unfairness that was committed against them. And actually, in reiterating and reinstating that wrong, that unfairness constantly, and that helped them deliver their message, right? There is a de facto ban on imports. Whatever Panama is doing, whatever they're saying, we cannot export, we cannot do this, and this is not justified for the purposes of protecting their tomatoes. They could have done something less trade restrictive. So there is this wrong or unfairness. Now, as a defense against that, maybe Panama could have had a stronger case of saying, yes, look, these are the statistics, but maybe they could have said, but as we can see, not only did we adopt a measure that complies with the requirements of an SPS measure, we have also seen a reduction of the presence of this plague. So even if there is a ban on imports, or even if de facto Costa Rica has not been able to export, we have been able to protect our production much better, our vegetables much better. And so the way you build your story and the way you tell it should be a very human way, very easy to grasp, and should always respond to this common sense perspective. Right? Even if we're dealing with governments, with human rights issues, with very complex treaties, we should always go back to how we tell a story. And with this in mind, my conclusion regarding how to build a case theory, I hope this was helpful. But my conclusion would be, we often hear about storytelling as a moody or as a moot court contestant important ability, and we think it's just speaking nicely, being a good orator. And it's not that. It has actual real life implications, as you saw from this case. And so with this in mind, we'd go to IRAC. I don't know if, Claudia, if you think it's good if we give a 5-minute break, or if you think we should go on.
I think if we can go on, we should go on.
Okay.
Because, yeah. Since there's no participation, like an active participation, I think we could go on. If you're okay, or if you need 5 minutes, we can wait.
No, it's perfectly fine with me. Yeah. I was thinking of the students, but the final part of this presentation is how to present the case theory, right? It is one thing to listen about building a case theory, but there's another presenting it in an orderly fashion. And this is where we sometimes fail, or where we get really frustrated when we're preparing for a moot court hearing, for example, and when we're drafting written submissions. And it is, how do I present it orderly and in a clear fashion? And should each person follow the order with which they feel more comfortable? Or I've also heard this as a coach. Well, the argument's there, you know. You see a mess, you see diagrams, but the argument's there. I'll know how to present it during hearings. Well, will you? Right? That's the issue here. And there's actually a standard to present a case theory, to present your arguments, which is known as the IRAC method, or the CRAC method, and we'll address it briefly. And remember that in a case theory, we're dealing with a legal theory and a factual theory. So in essence, we're dealing with rules and facts. But these rules and facts are not necessarily in order, or I don't necessarily know what to do with them as a tribunal. So it is your job to identify the relevant rules, to identify the relevant facts in the compromise or in the case, and to present them in such a way that they make sense and that it is perfectly crystal clear to me why I should rule in your favor, why you have the right to relief. I always like this little boxes example because I think this is what IRAC does, right? It matches the facts of the case perfectly to rules. This is what you should be aiming at. So the IRAC or CRAC method, probably some of you have heard about this, or even all of you. Those of you who haven't, what IRAC means is issue, rule, application, conclusion. What CRAC means is conclusion, rule, application, conclusion. They're basically the same. What changes here is the first element. We would normally use IRAC for, say, legal opinions for that type of document. And we would normally use CRAC to present legal arguments in litigation, say in a written submission, say, or brief, or say during a hearing. This is the standard we follow, and this is the order of analysis. We first present the legal issue, and in IRAC we do so as a question. We present it as a question. We're analyzing whether such and such measure falls within the scope of a certain legal provision. But when we're litigating or presenting arguments, we're not presenting open questions to the tribunal. We need to, or to the trier of fact, or to the decision makers. We need to make it very clear what we need them to state, because we need them to tell someone else to act or to behave in a certain fashion. So when using CRAC, we state the issue as a conclusion, right? Such and such measure falls within the scope of article such and such from any given treaty, right? Then the rest of the IRAC or CRAC methods, the R, the A, and the C, are the same for both, at least in terms of the order in which we present. So this is an example that we'll be using to speak about the IRAC and CRAC methods. Well, one of the articles in the founding treaty of the Central American Economic Integration Subsystem states the following, right? State parties shall maintain full freedom of transit through their territories for the goods destined to any other state party or transport from such states, as well as for the vehicles transporting those goods. Now, don't worry, this sounds a bit it looks like a jigsaw puzzle the way it was drafted, but it basically means states should grant freedom of transit. What transit means is going through the territory of a country, but not when goods are destined, or products are destined for such country. They're destined for a different territory. And simply a truck, for example, needs to go through that territory to reach its final destination, which is somewhere else. It's in another country. You're probably familiar with this if you've gone through airports. You often go through airports in transit because you have a layover. You're not going to the US, you're going from Latin America to Europe, but you have a layover in Miami, right? It's the same, right? The freedom of transit for goods would imply that in international trade, a country should allow goods that are destined for another territory outside of its own national territory to go through their roads, to go through their territory with freedom, right? This is a very basic principle of international trade. It's in our regional treaties, but also in the General Agreement on Tariffs and Trade, Article 5, for example, in the World Trade Organization. And okay, let's suppose to speak about IRAC and CRAC, let's suppose that State A, that's how we'll call a particular country in this case, enacted the Transportation Sector Protection Act. It's a protectionist measure, even from the onset, from the title onwards, we know it's a protectionist measure, which reads, in the authorization of transit operations through national territory, preference shall be given to goods transported by vehicles with national registration plates, which are operated by local carriers. So what is this law saying? Oh, well, there is a regional treaty which requires that you maintain full freedom of transit. Well, actually, no, what we're going to do nationally is that we're going to give preference for international loads or goods, but that are transported by vehicles registered in our country and operated by local businessmen, right, by local carriers. So it's a protectionist measures for a particular service sector, particularly transport or transportation. And let's say we want to present an argument. We initiate a dispute before following the rules of our dispute settlement system in Central America, and we want to present an argument regarding a breach of Article 28.2 of the Guatemala Protocol, or the Protocol to the General Treaty on Central American Economic Integration. We want to say that this provision in this particular act is incompatible with Article 28.2. It's a violation of a treaty. Okay, so what do we do with IRAC? I'm only using this example to convey the following message, the way we use IRAC. So first we go with the I, or with the C of the CRAC method, right? So the issue, or the issue stated as a conclusion if we're litigating. So in this initial section of the CRAC or IRAC that you're building, you should state that the issue should be decided in favor of your client or party, and indicate your reason briefly. So we have a sample here on how you do that. And this would be what I would consider the best practice on how to present the issue. And right here, we're actually using CRAC, right? Because we're stating it as a conclusion. One way of presenting it would be to state, or to say, the Transportation Sector Protection Act adopted by State A breaches Article 28.2 of the Guatemala Protocol. That's the name of the treaty. It's a summarized version of the name. By granting an origin-based preference for certain goods in transit on the basis of the nationality of the vehicles which transport them. Now, the virtue of this presentation, the virtue of this sample, is that, as you can see, the tribunal will know what your claim is immediately. And this is what you want to achieve during the competition and during your professional life if you're going to be acting as litigators, right? It states the relevant measure, it states the provision which is breached, and it gives us a very brief version of why it breaches such provision. Now, we have another example here. This would be a good way of presenting the issue or the conclusion, in the initial conclusion in the CRAC method, but it's not the best, perhaps. Look at this. The Transportation Sector Protection Act adopted by State A breaches Article 28.2 of the Guatemala Protocol. I mean, it's good, it's clear enough. But unlike in the first sample, or the first drafting sample, or oral submission sample, it doesn't tell us why. It doesn't tell us why this particular act or government measure breaches Article 28.2. And I think it's always better if you can tell the tribunal what you're going to be presenting as an argument, right, from the onset. That will help your case. And we have what I would call a suboptimal way of presenting this. This tribunal should analyze the Transportation Sector Protection Act in light of Article 28.2 of the Guatemala Protocol. There's a little mistake there, but okay. It doesn't really tell us what the tribunal should do. It doesn't tell the tribunal what you expect in terms of relief, right? It's a very open-ended way of presenting your arguments. And so the initial statement, as you can see from these three different samples, should be very clear in stating that the issue should be decided in favor of your client, and indicating briefly the reason why, right? Such and such measure is incompatible with Article 4 of the GATT, the General Agreement on Tariffs and Trade, as it de facto discriminates against foreign exports of tomatoes. This would depend, of course, on the particular facts of the case and the relevant rules. But I hope you get a sense on how to present this initial conclusion. And then once you've done that, you go to the rule, right? You've stated the issue either in a question or in a conclusion form, as a question or as a statement, depending on the context in which you're drafting a document or in which you're presenting an argument verbally. Then we go to the rule. And when presenting the rule, you should follow this order. You should go from general to specific, right? You can quote case law and you may add an explanation of the rule. This is what's sometimes called CRAC, right? It's not CRAC, but CRAC, right? Conclusion, rule, explanation of rule, application, conclusion. So for example, going from the general to the specific in this case, we would go with the treaty article first. Article 28.2 of the Guatemala Protocol requires such and such thing from governments, right? And then you go into more specific details. In the case concerning such and such goods or in such and such dispute, the arbitral tribunal determined that Article 28.2 implied blah, 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 right? You begin quoting your case law, you make rules more specific, or you present a particular interpretation of the terms of the rule. Remember that, for example, you can always conduct interpretations of international treaties according to customary law, and particularly Article 31 of the Vienna Convention on the Law of Treaties. Sometimes it will be necessary to state, according to its ordinary meaning, the term transit, for example, refers to such and such type of operations. Right? You clarify what the rule means, going from general to specific. Once you've stated the rule, you go to the application. And application means that you identify similarities and differences between the rules and the facts of the case, right? It's a contrasting exercise. You know the rule, you know what it clearly states. Now you tell me how the facts are similar or different from what that rule states. You should present this analysis in order, following the different elements of the relevant rules of the case, right? And oftentimes you can follow previous approaches when it comes to the order of analysis, right? When a certain provision has been interpreted before, particularly by a tribunal, an international tribunal, a court, or any body, then that body might have provided a certain order of analysis. It might have subdivided the rule into different elements, and then you can follow that previous approach. But sometimes you won't have that. And in that case, I think it is your job to try and identify the different elements or keywords within a rule, and then subdivide the analysis according to those elements. That is much better than oftentimes trying to present too much information regarding a certain rule, and you could have subdivided the argument into sub-issues, right? So for example, when dealing with Article 28.2 of the Guatemala Protocol, as we have been doing so far, we can subdivide the argument into smaller sections, right? So for example, we want to discuss what it means to maintain full freedom of transit. And you might want to argue, well, what full means. Well, there is a certain freedom of transit, but it's not a full freedom because you've restricted it significantly. Or maybe that's not relevant, but this is just an idea. You can also see that Article 28.2 refers to freedom of transit for goods, for vehicles. It also refers to contractual freedom. It's not quoted in this presentation, but it also refers to contractual freedom as related to freedom of transit, right? If you have freedom of transit, you should be free to decide which carrier to contract, to hire. And so you might want to subdivide the analysis. Okay, this affects goods in such way, this affects vehicles in such way, this affects contractual freedom in such way. And therefore, we see the measure breaches Article 28.2, right? But it is very important that you conduct your analysis according to the different elements of a particular rule or principle that you're invoking. And then, once you've done that, you state the conclusion, or you, in the case of CRAC, restate the conclusion. This conclusion should be composed by brief statements. You should not extend yourself during the conclusion too much. It's a result of the analysis, of course, and it should mention both facts and rules, right? For example, in light of these reasons, the Transportation Sector Protection Act breaches Article 28.2 of the Guatemala Protocol, as it restricts freedom of transit for goods not covered by the preference it establishes. Right? As remember, the hypothetical law we were mentioning established certain preference to authorize transit operations. So this would sum it up very briefly, right? But I think it's important in the conclusion to state both facts and rules in a very concise manner, because that will help the tribunal remember what your message was, right? It breaches article such and such because this happened in a very simple fashion. So with this in mind, I think with this presentation, we have covered both case theory, how to build a case theory, an actual example on how a case theory might be applied, be constructed, and might be developed in real life. And then we have seen the IRAC method, which is how to present that case theory. It is important that you follow this standard. This is the standard when presenting your argument. So I hope this is useful to you. And if there are any questions, I'd be happy to answer them. Or if not, well, I hope this was very useful, and I wish you good luck in the Jessup competition.
Thank you, Andres. It was very useful, and we have I'm going